Afternoon, Alex.
Good afternoon.
Okay, this is part 3 actually of a series of videos that we've been working on, introducing Alex Radford, English solicitor, Spanish abogado, covering the whole of Spain.
Yeah, so we've been talking about, you're here today, what things can you do to mitigate inheritance tax, put your affairs in order, like signing a Spanish will, signing a power of attorney, putting letter of wishes in place, sharing your confidential and financial information with either professional advisors or loved ones, and just kind of preparing, for that eventual day when we'll all depart this lovely earth and move on to the next place. Mm-hmm. So it's about making it easier for your heirs and beneficiaries to deal with the Spanish estate, because it's an awful period in people's lives when someone dies, and having a Spanish property and Spanish assets makes it just a bit more complicated because people don't speak Spanish, and it's a foreign country, they're in their own country, maybe they're here, maybe they're somewhere else, but by and large the clients we act for tend to be clients from all over the world who have lost someone who either lives in Spain or has assets in Spain. And we're here to guide them through the process to inherit those Spanish assets.
Okay, so this is a procedure process that, as you say, can be complicated, a little bit daunting, foreign country, not speaking the language. So what you're offering here as a service, in addition to all the other like the wills and the inheritance tax advice, is really to cater for the family, either the spouse or the family as a whole, to claim and deal with the inheritance and make sure that the procedure goes smoothly.
Absolutely. So for example, Marco, one of the first things that people will do when we see them is that they'll bring us or send us an original death certificate. And if the deceased died in Spain, and then the original death certificate from Spain is fine. But if they died abroad, and we need an original death certificate from the client's from the deceased's home country, and that needs to be stamped with the apostille of The Hague, and then that comes to us in Spain, and we can arrange a translation of whatever language is necessary. So we've got the original death certificate stamped with the apostille of The Hague if coming from abroad, with its translation, and then we would apply for what's known as the certificate of last wishes, and we would go along to the civil registry, and we'd say to them that this person, which complete the application form, say this person died on X date. Here's a copy of the death certificate. Did he have a Spanish will, and did he have any insurance policies in place? And the civil registry will issue a certificate confirming or not if a Spanish will was signed. And if a Spanish will was signed, then it will state the notary before whom it was signed, the date, and the time. And if there is insurance, then they'll issue a separate insurance policy stating the number of the insurance policy and the provider of that insurance.
When you say insurance relevant to?
So, for example, if someone has a mortgage over Spanish property, right, and they've got life assurance in place.
Okay.
So, in effect, the certificate issued by the civil registry will also confirm if there's life insurance policy in place to, say, settle that mortgage.
Okay, so when we're talking about insurance here, Alex, it's relevant to insurance for your financial obligations and insurance that's registered against assets.
Yes. Yeah.
Right. Okay.
So what happens next is that once we've got the certificate of last wishes, certificado de últimas voluntades, we'd see if there's a Spanish will or not, and if there is a Spanish will, we would then contact the notary. Usually where we're based, and we'd ask them to request a copy of that will from the notary where the deceased signed the will. So in effect, you can go to any notary, and the procedure is you ask your local notary to request that will, and that our local notary would contact the will anywhere in Spain and say, Mr. here's a copy of the certificate of last wishes. Mr. X died on X date. Here's a copy of the certificate. Please send a copy of his last will through to us. And then they'd send that last will through to us, and we'd collect that and review that with the family. But before we can do that, the notaries always insist on seeing a power of attorney for us to request a copy of the will. So unless they're here in person, and we go along with them in person to the notary, which largely doesn't happen, we would put in place a power of attorney, which they can sign in their home country. And that power of attorney is a document that authorizes us to apply for the certificate of last wishes, deal with the inheritance, sell any assets if necessary, and then register those in the name of the heirs and executors. But the Spanish notary won't release a certified copy of the last will until we've got a power of attorney. And you might say, well, look, I've already got a copy of the last will. I don't need another copy. Well, actually, we do, because any notary that you signed an acceptance of inheritance before, you have to provide the certified copy. And that certified copy is only, so a new certified copy is only issued once you request it using the certificate of last wishes.
Right. So if I'm just an example, I'm in the UK. I'm a member of the deceased family, and I need to come along to a solicitor, an abogado, a lawyer in Spain, to help me with claiming the inheritance. This is the procedure that you're talking about. But
yes.
What if you don't have the power of attorney?
So in effect, we would send the power of attorney to the clients by email. So we act for clients inheriting Spanish property all over Spain, and we prepare the Spanish power of attorney, send that through to them in English and Spanish. They book an appointment with a notary. We'd send them signing instructions when they meet up with the notary, take their passport along with them, and then they'd sign the power of attorney with the notary. The notary will arrange the stamp of the apostille of The Hague. That power of attorney comes back to us, and then we can apply for a copy of will. And I say that because that's only if there is a copy of, if there is a Spanish will, there may not be a will. And if there isn't a Spanish will, then the deceased is treated as having died intestate in Spain. And then usually, and depending on where they lived and where they were resident before they died, the laws of their nationality apply. So in the case of the British person, if they weren't resident in Spain, then Spanish law, if they weren't resident in Spain, then in effect the laws of England would apply. And if they had an English will, we'd look at whether that English will refers to the Spanish assets. And if it does, great, we would deal with the Spanish estate under the English will.
Oh.
And the heirs and beneficiaries would then have to apply for grant of probate. And then once they've got grant of probate, we would need the original grant of probate stamped again with the apostille of The Hague, which can be organised at the legalisation office, and that comes out to us, and we organise a translation. If there was no English will and no Spanish will, then we would require what's known as letters of administration. And again, a UK law firm and solicitors can apply for that for the clients there. And once that's been issued by the court, it has to be stamped with the apostille of The Hague, sent to us, and then we can progress the Spanish estate.
Okay, so really, I mean, it sounds quite complicated procedure, and there's lots of different issues that could come up if things aren't done properly in the first place. So I think really the advice that I can hear from your explanation, Alex, is power of attorney, Spanish will, and make sure that any procedure then, in the case of a death, is going to be a lot easier and less complicated than what it can be, what you're explaining.
Yeah. So, and it goes back to what we've talked about in previous videos. If you've got a Spanish will in place, it's going to make life much easier for heirs and beneficiaries to handle the estate. So once we've got the certificate of last wishes in place, we've got the original death certificate, we've got the power of attorney, we can then start to value the assets. And that means we can, for example, contact the bank if there's a bank account, and we'd ask them for a certificate as a date of death. And we typically also ask them for statements for the last 12 months. And the bank would send us that information. And at that stage, banks tend to block the account of the deceased. If it's a joint account, then they'd only block 50% of the account. The rest of the account and the monies there could be continue to be used by the surviving spouse or partner or account holder, and they'll continue to let direct debits and expenses come out. So we request that certificate from the bank so we know how much money was in the bank account as at date of death. And then we look at what other assets there are. So, for example, if there's a car, we'd ascertain the value of that car. If there's a house, we'd ascertain the value of that house. And we'd gather all the assets together, put them down in a valuation. We'd calculate whether or not inheritance tax is payable. And let's just assume that no inheritance tax in this case was payable. We would then prepare the deed of acceptance of inheritance to be signed before a notary, and we would say to the notary, look, this person died in for example the UK on this date. Here's his original death certificate stamped with the apostille of The Hague. Here's his certificate of last wishes, which confirms that he had a Spanish will. Here's a copy, an authorised copy of the Spanish will, and it leaves the assets to these heirs. Here's our power of attorney confirming that we can act for those heirs with their relevant NI numbers, which are their Spanish tax numbers. And then we would say, and these are the assets that the deceased owned before he died in Spain, and these are the values. And they would put that all together in a deed. We'd sign that deed, accepting the inheritance on behalf of those heirs. So, for example, recently we acted for clients who inherited a property in Gran Canaria, and and it was basically four brothers and sisters inherited that property. So we had powers of attorney from all of them, and we accepted that inheritance on their behalf. We then, after we've signed that deed, we would then collect the deed from the notary, pay the notary fees, we pay any inheritance taxes if there are. Even if there aren't, we have to put in what's known as Modello 650. So that's basically a tax return, zero tax return if there's no tax payable, and if there's tax payable, we calculate the tax, pay that. And then we take the deed, we submit the deed to the land registry and register the property in the heirs' names. And then once that's deposited at the land registry, they may come back to you and ask you for additional documents or not. But assuming that's all okay, because we've done our homework properly, the deed would then come back and say, this is all registered in the name of the heirs, and then that is the procedure complete as far as the property is concerned. If there's bank accounts, we would then contact the bank and say, look, here's the deed of the acceptance of inheritance, here's Model 650 confirming the taxes have been paid or a zero return has been submitted. These are our powers of attorney. Here's the death certificate. Here's the certificate of last wishes. Our clients now wish to accept the monies in that bank account. And the banks then will do kind of one or two things. They'll either transfer the monies to our client account, and we then send that on to the clients wherever they're based, or the clients, if they want to, if there's a property involved and they want a bank account for direct debits, then we'll set up a new bank account in the names of the heirs and close the old bank account down and transfer those monies to the new bank account.
Mm-hmm. So a bank account, just going back to that point you made on the bank account, it's advice then for husband and wives, partners, to open a joint bank account in Spain in any case, because if it's not, that money's frozen and there could be difficulties with certain costs and expenses, possibly, funeral and other expenses. So it's really a good idea to have joint accounts, isn't it, for Spain?
Yeah, definitely. I'd recommend joint accounts so that basically the assets are held jointly, and also so if you had a single bank account and you left all that money to your spouse, then she or he could actually pay tax on that. So a joint bank account, when you've got assets in Spain, basically the more people you leave them to in your Spanish will, or the more people you leave your Spanish assets to, the less inheritance tax will be payable.
Yeah, and that could be quite beneficial, again, just going backwards on making sure that, in the will that, your partner's going to live in the house anyway, it's going to be passed on to the children. So, of course, why not split it in as many ways as possible and reduce the tax?
If tax is payable. So again, one of the first things we should consider is how much inheritance tax is payable.
Yeah, and that's down to where the property is in one of the autonomous regions, because it changes across Spain.
Correct. Yeah.
Okay. Well, that's great advice, Alex, and very important advice, really, because people get caught up in this on a very frequent basis. I bet you see all kinds of issues coming out of the Spanish system.
Yeah, I think the most important thing is that it's if you can put in place a Spanish will, it makes life much easier for your heirs to manage the estate, and that's our kind of. That's what we really want to talk to clients about. Put in place a Spanish will, make it easier for your heirs, beneficiaries to manage the estate when you pass on.
Yeah, and the power of attorney is obviously very important to be done at the same time, and make sure that this is signed. Both partners should have, a power of attorney, so they're done separately. Is that correct?
Well, let's be very careful here, Marco. So when you're putting in place Spanish wills, then it's important to, I'd say, advisable to have a power of attorney to each other. So Mr. and Mrs. have, say, mirror wills, leaving assets to each other and down to the children, if they, for example, lived here. Then they can also put in place a power of attorney, and they give powers of attorney to each other to manage their affairs if anything goes. So if they become less mobile, if they start to lose mental capacity by suffering from a degenerative disease. So that's the powers of attorney. When we're dealing with the acceptance of the inheritance, it was the heirs and beneficiaries which would sign a power of attorney normally in our favour, so that we can complete the inheritance for them. Mm-hmm. So you've got powers of attorney to deal with an inheritance, and then you've got basically lasting powers of attorney to between spouses to manage their Spanish affairs.
Yeah, perfect. And people that think, okay, well, I'm all covered. I've done my will in the UK. I'm all covered. No, because there's still going to be issues if you don't make sure certain things are in place for your assets in Spain. You can't just rely solely on the fact that you've got a will, an English will. Is that correct?
Yeah. So an English will, if they didn't have a Spanish will, then we'd look at an English will and see what the English will says, and see whether it refers to worldwide assets. And if it did, then in effect, the heirs and beneficiaries and executors would have to apply for grant of probate in the UK. They get grant of probate, they get the original apostille that comes out to us in Spain, and then we can manage the affairs, the estate here in Spain. But that takes time to get grant of probate. So that's already delayed dealing with the Spanish assets. Whereas if you've got a Spanish will, straight after someone's died, more or less, we can start to deal with the Spanish assets. Yeah. So that's why, again, we one of the advantages of having a Spanish will.
Yeah. Okay. And really, this whole content of this video is out there for people that are related and people that are, family members to anyone that has Spanish assets. So it's going to cover a lot of people that don't even live in Spain. They don't have themselves. They don't have assets in Spain, but a member of their family, close family, are obviously the people with the assets, the owners of property. And this is why it's so important for everyone to understand what the procedures are and what they need to do, and the reason they need to contact yourself, Alex.
Absolutely, yeah.
Okay, so just remind everybody the website that they need to go to for this.
So you can contact us on our website on legalservicesinspain.com. Click on the contact form, and there's also telephone numbers on the website as well. Contact us for a free consultation. Happy to discuss Spanish wills and how to structure them to mitigate inheritance tax. And of course, we're also happy to calculate how much inheritance tax your heirs could potentially have to pay.
Perfect. Great advice, Alex. And we look forward to doing some more videos with you in the future. And have a nice afternoon.
Thank you very much. You too. Bye now.